All right, welcome everybody to another question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru, Tumarkin, and I will be with you as usual for the next 30 minutes to answer all of your questions about employment issues, workplace issues, whether it be severance pay, terminations, workplace, issues like harassment, whatever the case may be. I'll be here for the next 30 minutes to answer your questions. So if you have a question, please do send it in. I'll be happy to answer it over the next 30 minutes or so. I will start to get into the questions. We've been getting a lot of questions lately, so I anticipate that today will be no different. I expect we'll get lots of questions about vaccines and, more specifically, vaccination mandates in workplaces. That's been a very hot topic recently for very good reason, and we've been getting a lot of questions about that. So if you yourself have a question about a vaccination policy or mandate in your workplace, or perhaps someone that you know, someone that's been affected by a mandatory vaccination policy, whether it be a friend or a family member, whatever the case may be, send in your question. It's a very complex topic. It's a new topic, one that we're all trying to, navigate right now as best we can. And so lots of questions about that coming in over the last few weeks. So if you do have those questions, please do send them in. No time like the present. I'm happy to answer those questions and assist you as best as I can. So with that, having said that, I'll jump right into the questions. I'm already getting a couple here. And then if I have time, I may get to other things that I did want to talk about today, but I'd rather answer your questions first. So I'll get right into the first question. We have a question from Cheryl on YouTube who says, if I get the first shot and decide not to get the second, am I still entitled to severance if I get a leave? Okay, so specifically, Cheryl, what I think you're asking about, if you get put on an unpaid leave because your employer has put into place a mandatory COVID-19 vaccination policy, and you're not considered, fully vaccinated under that policy, if as a consequence of that, they put you on an unpaid leave, are you entitled to severance? So that's a good question. It's a situation that a lot of people are dealing with right now. If you are put on an unpaid leave in an industry that is not mandated by the government, so, as an example, in Ontario, long-term care home employees are all now mandated by the government to have both doses, to be fully vaccinated. Otherwise, they cannot continue to work. So if in a situation like that, you wouldn't necessarily be owed severance because the government has actually changed the law. However, for all of the other situations where there is no actual government mandate that has changed the law, if your employer puts you on an unpaid leave, in other words, they're not allowing you to work and they've stopped paying you, that would amount to what's called a constructive dismissal, meaning that you would be entitled to severance pay because your employer is not outright letting you go. They're not saying you're fired, but what they're doing is the same thing. They're saying because you're not getting vaccinated, because you're not fully vaccinated, it doesn't comply with our new policy that mandates vaccination. And so we're putting on unpaid leave and we're not paying you. That would amount to a constructive dismissal in most situations if you refuse a vaccination and you're put on an unpaid leave. Again, I can't stress this enough. As long as you're in an industry that has not been mandated by law to be vaccinated. And so as of today, there aren't many of those. There's long-term care homes. There are certain restrictions and mandates put in place for hospital workers, but the mandate is not vaccine or nothing. And so even in a hospital setting, you would still be entitled to severance. So Cheryl, if that's your situation, you're being put on an unpaid leave, you're not in an industry that's been mandated by government, get in touch with us. You can contact myself. You can contact any of our lawyers. My contact information specifically is on our website at employmentlawyer.ca. So if you go to our website, you can contact me directly through there. You can email me or you can call me, whatever works best for you. I'd actually recommend that you do that rather than contacting our firm's general number, because I'll be able to get back to you very, very quickly. So you should definitely get in touch with me directly on this one. I have another question here coming in. I have a question from Andrea on Facebook who says, what piece of law says employers are responsible for paying for COVID testing policy? Does this apply when the government mandates for public sector employees? So with respect to COVID testing, that's something that we've seen come into place in a lot of workplaces. And in a lot of workplaces, the rapid testing is actually an alternative to being fully vaccinated. So if your employer has implemented a testing policy, it has to be at their own expense. So what that means is, as an employee, if your employer is implementing a rapid testing or a testing of any kind policy, you are not responsible for paying for that. Your employer is responsible for paying for that. And that's supported, Andrea, by the Employment Standards Act, as well as the common law. So there is quite good legal support for that, that position. And in terms of the government mandate, so if the government is mandating, I don't know if I understand your question. If the government is mandating testing, then again, the employer would still be responsible for paying for that. It would never fall onto the employee to pay for that. But I don't think, as of today, the government has actually implemented that as a policy, as a mandate in terms of rapid testing for public sector employees. For federal employees, it's more of a vaccination mandate rather than a public sector, rapid testing mandate, if you will. So if you have a more specific question about that, if I haven't answered that part of your question, send a follow-up question in. But that's how it would work with respect to the expense of the testing. I have a question from Katrina on Facebook, who says, if put on a leave of absence, will we get EI if the leave of absence is forced? So I'm assuming, Katrina, that you mean because you've refused to be vaccinated in the face of a mandatory vaccination policy in your workplace. So this is yet to be seen. We're going to get more information on this next week, actually. So keep an eye out in the news next week, Katrina and everyone else who's interested in this issue, which is probably a lot of you. But the Minister of Employment has actually come out federally and has said that, her opinion on the matter is that people should not get EI benefits if they are put on an unpaid leave or terminated because of failure to comply with a mandatory vaccine policy. Now, we won't get into whether we agree or we disagree with what she's come out and said, but that's been what has been said. That's been in the news this week. But the actual determination and what will happen with respect to EI benefits and will people get those or not is actually yet to be officially made. As of right now, I can tell you that there has been a directive provided. And it looks like the federal government is leaning towards denying people EI benefits who are put on an unpaid leave, who are terminated because of a failure to comply with a mandatory vaccination policy. So it does look like it's going to go that way, but nothing is solid yet. Nothing is official. So we'll have to wait until next week when there should be an actual official announcement on that. But I can say that, unfortunately for the time being, if you're looking for EI benefits for having, been put on a leave or terminated because of a refusal to be vaccinated, you may not actually be in receipt of those benefits. So I have another question here from Alexa on Facebook who says, is it okay for employers to mandate vaccines for grocery store workers? So the way that the law works on this issue is that in terms of the implementation of the vaccine policy, there isn't actually a law that prevents employers, as of today, from implementing these types of policies, as general policies. But the rationale will obviously vary from industry to industry. So when we're looking at the situation from a legal perspective, we want to look at whether the policy was necessary and whether the policy was reasonable in light of the surrounding circumstances. So, for example, an employer might have an easier time making out the fact that it was necessary or reasonable in a grocery store, excuse me, where there's a lot of public contact versus, let's say, a tech company where people are working remotely from home. So you can see there's quite a big discrepancy there, and there will be different circumstances from one employer to the next in terms of how they can rationalize or justify the policy being put into place. But it can't be, as for your question, Alexa, it can't be kind of prevented at this stage. It's more a question of what happens if you refuse to be vaccinated in light of a mandatory vaccination policy. And as of today, Alexa, if you refuse to be vaccinated and your employer is a grocery store that implements a mandatory vaccine policy, and they let you go because you refuse to be vaccinated, you would be entitled to severance pay. I have another question here from Kat on Facebook who says, can I demand severance if I'm being suspended without pay in a telecom company? Does telecom fall under federal government worker regulations? So telecom companies are federally regulated businesses. So it doesn't fall under, for example, the core public administration mandate. So the mandate that has come into place over the last couple of weeks by the federal government that states that all federal government employees that are part of the core public administration need to be double vaccinated by October 30th in order to continue working. That's separate. That applies to only those employees that work for the federal government. For federally regulated businesses like telecom companies or banks or transportation companies, for example, some of those will begin to be mandated by the government. As of today, Kat, they haven't been. So telecom companies have not been mandated by the government as of today to have a vaccination policy or to be vaccinated, double vaccinated in order to continue working. It may come. It's very difficult to say, but that is not one of the industries that has been earmarked so far by the federal government compared to, for example, the transport industries. So if you work in airline transport or marine transport or railroad, those industries specifically that are federally regulated will be mandated by government. Just like the federal government employees. But for telecom companies, so far that's not part of the mandate. So if you are put on a leave without pay because of your refusal to be double vaccinated, certainly, as I mentioned earlier, you can treat that as a constructive dismissal. Of course, it depends on the circumstances, but in most cases, that would amount to a constructive dismissal where you would be able to pursue severance pay. And if that is your situation, Kat, again, get back and get in touch with us. You can go to our website, employmentlawyer.ca, and you can find my contact information and you can email me directly. You can contact me or you can call me directly on this issue. I'd be more than happy to help you, Kat. I have another question here from Tracy on Facebook who says, I'm unionized and placed on an unpaid leave for not taking the vaccine. Can I get a lawyer if I feel a union didn't represent me properly? So unfortunately, Tracy, when you are unionized, you have to go through your union. You can't have a private lawyer assist you. You can't sue in court like you would be able to do, for example, if you weren't unionized. And so if your union is supporting the vaccination policy and they've decided not to represent you, not to file a grievance on your behalf, unfortunately, there really isn't much that you can do because all that the union actually needs to do is to consider it. So as long as they consider filing a grievance on your behalf as a unionized employee, and they can show that they've at least turned their mind to it in terms of potentially representing you and potentially filing the grievance, but they've chosen not to, then they've actually complied with their obligation of duty of fair representation. So with unions, it's actually a very low threshold from a legal perspective of what the law requires in order to represent you, quote unquote, adequately or fairly. So certainly, it's something that you can look into further, Tracy, if you feel like they haven't turned their mind to it at all. I would guess that they probably have, because you're probably not the first person to raise this issue. And so it may be that you won't find the legal remedy that you're looking for, unfortunately, there. And so just to be clear, because we get this question a lot, if you're unionized, you have to go through your union. An employment lawyer cannot assist you. We can give you advice on the situation, but we can't represent you and we can't assist you when it comes to terminations or severance pay or any of those issues specifically. Just looking through the questions here, we have a lot of questions, so I'm just trying to get through as many as I possibly can. This is a question from Catherine on YouTube who says, I was put on an unpaid leave. I was offered the severance package. Should I sign it? The way it is drafted says, I resigned from my duty. I didn't resign. I was let go because of the mandate. Very, very short answer for you, Catherine. Don't sign anything unless you get it reviewed by a lawyer first. You really shouldn't sign it, especially if you're being asked to say that you resigned when you didn't. That's a red flag. So it may be that the way that you're going to choose to qualify the end of your employment, depending on what they offer you and depending on what you agree upon with your employer, it may be that you end up agreeing to characterize it that way. But you certainly should not sign anything or accept anything unless you get it reviewed by a lawyer first. So certainly you can contact our firm. We'd be happy to review it for you. You can go to employmentlawyer.ca. All of our contact information is there, so you can contact us that way. My contact information is on our website, so you can contact me as well. Myself or any of my colleagues, we'd be happy to review that for you and let you know where you stand, let you know what your options are. The odds are if they're offering you a severance package, they are not offering you enough. So it's really important that you don't just accept what it is that they're offering you, because you sound like you're in a situation of a without cause termination, meaning you'd be owed your full severance entitlements. So you have to be very careful here not to sign anything, because if you do sign something, it's too late after the fact. You can't go back and negotiate. You can't reopen the matter afterwards. You're stuck with what you signed. So it's really important in your situation, and anyone who's in a situation like this, always get it reviewed by a lawyer first before you agree to anything. So I have a question here from Louise Shane on Facebook asking about contacting us in Ottawa. So I myself work out of the Ottawa office. So you can contact me directly, and you would be able to go on our website. Again, it's employmentlawyer.ca. Go to our website, Louise. You'll see that all of our lawyers' contact information is there, including the lawyers in our Ottawa office. You can contact myself or any of the other lawyers in Ottawa in order to schedule a consultation or get the assistance that you're looking for. You can contact me. I also have my assistant's contact information on the website. You can contact her. So, any of the lawyers that you're trying to contact, definitely get in touch that way, and we'll make sure that we get back to you very quickly. Unfortunately, we've been getting lots and lots of calls regarding all of the vaccine mandates. So as you can imagine, it's been quite hectic. And so we're trying to get back to people as quickly as we possibly can. We're working, overtime to try and get to people and answer your questions and respond to you. Unfortunately, there are only so many hours in the day, but we are doing our absolute best. So if you find that you're contacting our office and you've been waiting several days to hear back, get in touch directly with one of our lawyers. Go on our website, employmentlawyer.ca, and email one of our lawyers directly, and somebody will get back to you. Otherwise, you can wait for the general line to call you back. We will always get back in touch as quickly as we possibly can. So we will never leave somebody hanging, but it is a very exceptional time right now. So Louise, especially if you're in Ottawa, contact me directly or any of my colleagues in Ottawa, and we'll get back to you there. So I have a question from Monica on YouTube. So very similar to something I answered earlier, I just wanted to confirm. Essentially, Monica is asking, can an employer ask employees to pay for daily rapid testing? The answer is no. Your employer has to pay for the testing themselves. So if this is the issue you're coming across, Monica, where you're fine with the testing, you're happy to do it, but you don't want to pay for it, you can push back on that issue and let the employer know that they're the ones that have to pay for it. If they're not willing, get in touch with us. We can certainly assist you in navigating that issue, but they should be paying for it. So I have another question here from Grant on YouTube who says, I need to fly to get to work as of November 11th or November 1st. I cannot get on a plane to get to work. Can my employer use this as a government mandate to end my employment and not pay severance? This is an interesting situation, Grant. So the challenge here is that a condition of your employment potentially is that you have to travel, or it might just simply be that you just have to get to work by plane. And that is a challenge, for sure, because essentially it's your job to be able to get to work. So if you can't get to work and your only way to get there is by plane, then that would be a situation where if you choose not to get vaccinated and that's the reason why you can't get to work, you wouldn't be owed severance in that situation because you would be left with two potential outcomes. Either you can't get into work, so it may be actually equivalent to a resignation if you don't show up at work and you abandon your job, even though that certainly would not be your intention. But unfortunately, that may be one result. The other potential result, Grant, is because you don't report to work or you can't get into work, they do decide to terminate your employment, or they take a position that it's frustration of your employment, meaning you're not owed severance pay because you can't get into work. But in any of those scenarios, you would not be entitled to severance pay because you basically can't get into work. It would be the equivalent of, for example, needing to drive to work and losing your license. Just to give an example that's a little more concrete, as an employee, it's your obligation to be able to get to work. And if you can't, that's not something that the employer needs to accommodate necessarily. So you can try, Grant, to have a discussion with your employer about it and see if they're open to something. I don't know what the nature of your work is, if there's an alternative, if you can get to work another way, if you can somehow, work remotely. It doesn't sound like it based on your question, but there might be alternatives there where the employer is willing to work with you because of the change in the law with traveling. Or they can also potentially place you on an unpaid leave unless and until the mandate for vaccination for travel is removed. So there are some options. None of them are fantastic for you, Grant, unfortunately. But those are things that you can potentially do in your situation. I have a question here from Mark on Facebook. Mark says, if someone was put on a performance improvement plan, did all that was required in the performance improvement plan, but still terminated for cause, are they still eligible for compensation? This is an issue that we deal with pretty often, Mark. So in terms of there being cause for termination, excuse me, cause for termination is a very, very high threshold to meet. And it's the employer that actually has to show it, not the employee, the other way around where you have to show they didn't have cause. So the burden rests on the employer. And there's two types of cause terminations. There's one type, which is more of a one strike you're out, where there's very, very egregious misconduct that's committed by an employee, such that the employment relationship can't continue and the employee wouldn't be owed severance. So to give you a couple extreme examples, if somebody were to commit theft or fraud or assault in the workplace, that could be a situation and would justify a termination for cause where that employee would be let go and they wouldn't receive severance pay. The other type of cause termination is more of a 3 strikes you're out scenario. And it doesn't necessarily have to be 3. That's just, an example. But it would be a situation where the conduct is less serious, but still misconduct nonetheless, and that multiple instances of that misconduct eventually amount to cause. And examples of that type of termination for cause are things like absenteeism, tardiness, of course, assuming that those things are not justified by something like a medical condition, because if they are, that would never be cause. But if simply you're late for work a lot, or you don't show up without an excuse, without a good reason, and then as well, performance issues. And so performance issues is something we see a lot when it comes to cause terminations. And most of the time, a termination for cause that's implemented because of a performance issue is not usually actually a cause termination. A lot of the time, employers will not do what they're supposed to do in order to be able to make out that case. And in most situations, the performance issues do not rise to the level that they would need to justify a termination for cause. So, for example, a performance issue specifically, if you're struggling with performance issues for months, your employer puts you on a performance improvement plan. They give you multiple warnings that if you don't improve your performance, it could lead to the termination of your employment for cause. You continue working, your performance doesn't improve, you get more warnings, your performance doesn't improve. If it continues like that and there's a progression of discipline applied by the employer, then potentially they may be able to terminate for cause. But again, it depends on the circumstances. So there isn't really a black and white situation for a termination for cause where with performance issues, it's a slam dunk for the employer, for example. So in your case, Mark, if you were on a PIP, a performance improvement plan, and you did improve, and that can be objectively shown, and that the employer gave you, didn't give you enough chances, or, performance really wasn't the main issue here. It may be that your employer is simply trying to get out of paying you severance pay. So it may be that they're trying to use this as an excuse or as a reason to get out of paying you severance pay. And if that's the case, that's not going to fly. That's not going to stand. These are actually cases that we get very often, where we're very often able to negotiate severance packages for our clients, because it's a very, very uphill battle for employers when they decide to terminate for cause for performance issues. So, Mark, I would suggest that you get in touch with me. If you're in Ontario, you can get in touch with me directly because I practice in Ontario. You can go to our website, employmentlawyer.ca, and look at my contact information and get in touch with me directly. If you're in another province, you can also get in touch with me, and I can direct you to one of my colleagues who's in BC or Alberta, depending on the case. But if you are in Ontario, get in touch with me right away, because I can certainly assist you with this, and the odds are you will be owed severance. We're just getting to the end of our time here, and I'm just going through my questions. There seem to be a lot of questions from people who are outside of Canada. So I just wanted to confirm that our law firm, Samfiru Tumarkin, is in Canada. We can't assist anybody who is outside of Canada. And specifically, we work out of the provinces of Ontario, Alberta, and BC. So if you are outside of that jurisdiction, unfortunately, I'm not able to answer your question, and I'm not able to assist you. If you're in Canada and you're in a different province, we may be able to provide you with a referral for another lawyer within your city, your province, that can assist you. But in the United States, in the UK, unfortunately, I'm not able to answer your question because the law works very, very differently in all these different countries. So I'll get to one last question. We're just out of time here, but I'll get to one more because I know there's lots of questions that I haven't gotten to. I'll do one more. And if you haven't gotten the answer to your question today, then do contact us. You can send an email to help@employmentlawyer.ca. We also, if you go to our website, employmentlawyer.ca, there are resources there with respect to vaccination mandates, and you can also send us an email through our website with respect to your vaccination questions. So if you didn't get an answer today, feel free to use those resources. I'll just get to this last question before we finish up today. So Sammy from Facebook says, if I refuse the vaccine, my employer is terminating my position with cause. Is this justified? And is it worth having a conversation to ask if I can be terminated without cause? So there should not be any situation where you're being terminated for cause for refusing to be vaccinated in a situation of a mandatory vaccination policy being implemented in your workplace. So if you're being terminated because of your refusal to vaccinate in the face of that type of policy, you should be terminated without cause. Again, only in these industries that haven't been mandated by the government, most of which have not. So if, Sammy, you're in one of those industries where it hasn't been mandated by the government, there's no termination for cause that should be applied to you. Certainly, we've seen it over the last few weeks, employers trying to make a case for termination for cause or terminating people for cause, but we're going to be fighting those tooth and nail because you should not be fired for cause in a situation like this. As I mentioned before, cause is a very high legal threshold that employers have to meet in order to justify letting you go without severance pay. And these kinds of circumstances simply don't meet that threshold. And so you absolutely should get in touch with us. When you ask about it being worth a conversation with your employer, you certainly can have a conversation with your employer, but they're likely being advised by their own legal counsel, and they're just going to listen to what their legal counsel is telling them. So it might not get you anywhere to do that, but you can certainly propose it. And if you are terminated for cause, or even if you're terminated without cause, Sammy, get in touch with us, because it's clear that if you're terminated for cause, you're going to be owed severance. If you're terminated without cause, you want to make sure that they're offering you what they should be offering you, because in most circumstances, it won't be enough and you'll be owed more. So that's the last question for today. As I mentioned, if we didn't get to your question, I'm very sorry. But you can go to our website, employmentlawyer.ca. You can get in touch with us that way. And we will be doing another Facebook Live next Wednesday, October 27th. Lior will be here to answer all of your questions. So you can also send in your questions then as well. So thank you very much for joining us. And I hope that everyone has a wonderful weekend.